Good afternoon, everyone. Thanks for joining in. We'll wait for about a minute more so that more participants can join, and then we'll start. All right. Good afternoon, everyone. My name is Devendra. I work with the State Innovation Society. Today, conducting this session along with Lex Orbis. This session is to, aware startups about IP in general, the patents, the quality testing, and certification. So the session is divided into two parts. First part will be taken by Lex Orbis. So Harshada from Lex Orbis will be taking the session where she'll talk about uh, what is IP, different forms of IP, what are the questions around filing patents, availing grants, etc. The second part will be taken by my colleague Siju Vargas. He'll also have a small presentation on the recently launched schemes, Government of Maharashtra schemes, where we are supporting startups based in Maharashtra with some financial and technical assistance in terms of filing their patents and reimbursement for their quality testing and certification costs. So any questions related to both the sessions, we'll take the questions after both the presentations are done. You can also, meanwhile, type your questions in the chat, which will take towards the end of the session. We'll keep it short, crisp. Any other questions, and if there's a need, we can always organize a advanced session in the later part. So I'll hand it over to Harshada. Harshada, welcome to the session. Uh, if you can hear me, please go ahead and share your presentation.
Yeah, hi. Good afternoon, everyone. I'll just share my presentation. I hope everyone can see it.
Yes, Harshada.
Okay.
Thank you.
Okay, so the first part of the uh, session, this webinar is IP basics. I went through a few of the questions startups had shared earlier, and we'll try to cover it during mine and Zijo's presentation. If required, as they've suggested, we'll conduct additional sessions for details, specific details. Um, Okay, so the agenda for my session is based on these points. We'll cover all these points one by one. We'll start with basics of intellectual property. Uh, when we talk about property, there are two types of properties. One is tangible, one is intangible. Tangible is which can be touched, which can be felt, like all the things. Just 1 second. I think we need to mute other participants. I can hear something.
I've done that, Harshada. You can go ahead,
Okay.
please. Yeah.
Okay. Yeah. So tangible property is the one which can be touched or felt. So everything you can see in front of yourself, the laptop or PC or phone you're holding, or you're attending this webinar on, is a tangible property. You can touch it. Intangible property is a result of creativity. It can be a screenplay, it can be a book, it can be a picture taken by you, it can be in form of media, idea, thought. So that constitutes to intangible property. So basically, intellectual property is any creation of the intellect. Now, when we talk about intellectual property, why startups need to focus on intellectual property? Uh, it needs IP focus is required because you need to protect your research and development efforts. Um, that protecting IP or thinking about IP also gives you edge over competition. You can see what your competitors are doing, and you can think of a better solutions, and you can use your intellectual property for having an edge over your competition. Also, you can offer your customers something new and different. You can add value to your services or products through intellectual property. Also, it is a way to monetize your creativity by way of selling or licensing your IP. You can also stop counterfeit products. You can stop others. So basically, intellectual property is a negative right. You can stop others from using your IP. Intellectual property helps a lot in creation of a brand value. It can be used as an effective branding instrument in marketing of your products and services. It's also owning what you're creating. So other than the monetary benefits, having that sense of ownership is also what comes with the intellectual property. Also, like I mentioned earlier, stopping the counterfeiting products, you can create a fence against infringement suits if you file for your IP. Now, how to identify different forms of IP? There are different forms of IP. You must have heard of patents, trademarks, copyrights, and designs. I want answers from the audience in this picture, in this product. What is the IP that you can identify? If you can just say it out loud or type it in the chat box.
Design.
Design for what, sir?
Design registration for mobile.
Okay. What else?
Mm, that's all, ma'am.
Technology, software. Okay.
The features.
Logo, correct.
The logo which or the design or the statement that never settle that they
Right.
have given.
Yeah, brand tagline someone has written also, great. Brand name, correct. So you can identify those. I'll just quickly run through all forms of IP. These are the
processes also.
business processes cannot be patented as such, but we'll go through the basic forms of IP, different types of IP. Many of you guessed what it was, like design. But how do you protect the design? Through which law do you protect the design? So for every form of IP which you see on the screen right now, there is a different law, there is a different act. For patents, we have
Arshita,
Patents Act.
Arshita, sorry to disturb. We can't see the other screen.
Um,
Yeah,
other-
now it's fine.
Now, can you see? No.
Yes, yes.
Okay, sorry. So, yeah, so these are the different forms of IP, which everything that you saw on the screen or that you came up with can be categorized in different forms of IP. So what happens is it's very important to understand which type of IP is suitable for your particular startup. Now, not everything can be patented or not everything can be protected under designs. Only inventions can be patented, provided they satisfy the criteria of patentability. We'll go through the patents criteria later on. But basically, what can be patented is only inventions, solutions. What can be protected under the Designs Act is shape and visual appeal. I'll give you some examples like a shape of a watch or shape of a car. those can be protected under design. Copyrights is more of music or artistic or literary work. There are also other things in copyright like cinematograph, screenplay. There are different forms of copyrights also. For our purpose, we should know that software code is protected under copyrights because in Indian patent law, software is not protected under patents under section 3. So only the source code can be copyrighted. Now, someone suggested tagline and logo. So all these fall under the trademarks law. How we can protect these? Let it be a word mark, a logo, or even the taglines are protected through trademarks. Now, understand that patents, designs, copyrights, and trademarks have their own laws. They have their own legislations. Their filing procedure is different. Their requirements are different, their time of filing is different, their validity is different. Um, Trade secrets are the ones which are not registered. So the best example for trade secret is Coca-Cola recipe. The composition of Coca-Cola is the biggest known trade secret. Usually all the recipes are protected through trade secrets. It's a confidential proprietary knowledge and they're protected through internal agreements. So there is no government which is regulating those. The last one is geographical indications. For example, Darjeeling tea, Kashmiri Pashmina, etc. So these are distinctive of a particular region. For this policy purpose, we should focus on patents, designs, copyrights, and trademarks. Patents are valid for 20 years. Designs are for 10 plus 5, that is 15 years. Copyrights are valid for lifetime plus 60 years. And trademarks are valid perpetually till the time you are paying renewal fees. So now that you know the basic differences, I want you to again go through this same picture and identify the forms of IP. I'm sorry, I just, okay. Can you see the slide now?
Yes.
It is
Yeah.
invention.
So can you please identify the forms of IP, different forms of IP as we went through now?
Never settle will be copyright.
Never settle is a tagline, so it will be a trademark.
Oh, trademark. Sir.
Yeah. I'll just show you the answers.
Logo is trademark.
Yeah. So logo is trademark, brand name is trademark, tagline is trademark. Coming to copyright, display screen, though that wallpaper is a copyright. The software code will be copyright. The unique body, that is the shape of the phone, will be design. Even although it is debatable, but arrangement of buttons and positions on screen, the icons fall under designs, and the data processing system that falls under patent, operating system that falls under patent. Okay, I'll give you one more example. Can you guess the IP associated with this picture?
Reva as trademark.
Correct.
The shape as design.
Correct.
The design.
The concept, electric vehicle concept has maybe patent.
Right. So one point is to be noted here that as you guys rightly pointed out, brand name and logo is trademark. The body design and shape is industrial design. All the components. So in single car, there can be more than 20,000 patented inventions. So one car comprises of different patentable inventions. So now that you have understood how to identify different forms of IP, we should understand why is it important to identify the IP. So protecting any form of IP requires money. It requires time and energy from the company's part. You should understand what form of IP is applicable to your particular product or service in order to segment and categorize it. What falls under trademarks, what falls under patents, what is design protectable. If there is only software, you can go through copyright. Fees and timelines are different for everything. You can assess the potential IP firstly understanding which form of IP is applicable. You can prioritize that at this stage of the company growth, you need to file, let's say, patent first. Then you can think of filing trademarks and copyrights. So you can prioritize and take business decisions and plan for you can make a strategy for the future based on the types of IP you identify. You can also manage investments based on the forms of IP, because you can set a chunk to go in patents, and you can arrange for investments uh, time wise and cost wise as well. Leveraging IP, because the cost is different and return of investment is also different. For example, patent protection is very broad. Comparatively, copyright protection is not that broad. Design protection is also very narrow. Because if someone makes little change in the design, then if you yourself are making changes in the design, you have to file different design application. So design protection is very narrow. So you have to understand how you are going to leverage what is the need of this form of IP filing right now, in order to think of, let's say you want to use it for getting investments, then you have to, or funding. So you have to focus on patent portfolio first. So you have to make a strategy, develop a strong, for developing a strong IP portfolio based on different forms of IP that you have thought of. Now, someone had asked a question that how to avoid mistakes, IP mistakes, or how not to do things in respect of IP. So, especially for patents and even other forms of IP, these are some of the mistakes that I have jotted down, which you can think of, that you need to be very aware of what different forms of IP are there. You have to understand that which is design, which is trademark. You cannot just say, I want to, this is a patented dialogue, because that is wrong. A dialogue cannot be patented. First thing will be lack of awareness. Second thing will be not protecting IP. You have to think about filing IP because it benefits you. It has a certain validity, and through that you can stop others from firstly using your inventions, and secondly you can make money out of those based on the IP valuation. Third point is blabbermouth, which is very important, especially for patents. If you are telling people about your invention, and if it is published anywhere or someone steals your invention, then you're letting go of novelty. You cannot file for patent, because in the patent system works first to file basis. It is not first to invent, it is always first to file. So the one who comes and files it first gets the intellectual property. Not recognizing appropriate form of IP is one of the important thing you should understand, because if you know what form of IP is applicable, you can strategize accordingly. Because startups, especially, once you understand, it's very simple concept. Once you understand that this is the IP which is associated with your particular company, you can make plans accordingly, so that you don't waste your time and energy, which is very valuable at any stage. Not finding white spaces in the domain, um, finding where IP is missing is one of the thing which startups can look over. So if you see that in your particular company's domain, if there is some research going on, and if you see there is a blank, there is a gap where there is a need of research, so you can make your investment of R&D in that particular gap. So in early stages, especially, understanding white spaces is important. Not identifying key players, so you always have to conduct this research through patents, or even just normal search online, identifying the key players which can be your competitors in future. You have to have a proper strategy, because there is no point otherwise. You will again get carried away from the path that you want to go ahead on. Also, not considering IP as an investment. You need to understand how IP works, then you will understand how money can be made through IP. So licensing and commercialization forms a big part of it. You have to, the three things that are mentioned in the lowest row is more on a attorney's side. So ignoring IP filing standards, the draft should be up to the standard. It should be a good draft when you're filing for a patent or even trademarks. All the examination reports should be replied properly. IP documentation should be proper, and due diligence, whatever is required, you have to provide it. So you have to ensure that the attorney and you are communicating positively in order to comply with all the requirements for IP filings. Now coming to the patents part of it, journey of an innovation to patent. um, so all inventions or all innovations cannot be patented. Any idea, what is an idea? It's a thought, it's a plan, maybe a suggestion. A suggestion for what? For solving a problem. So this solution to a problem, you have to think of it in a way how to convert it into a an asset which can be protected through intellectual property, especially through patents. So once you have an idea, you have to, the first step is always conduct a research, get a fair idea of the problem that you're trying to solve. How many people are facing this problem? Explore more information, do market research, do patent research. You can always go to Google Patents, put in normal keywords, it's like a Google search. Go through the patents, what people are uh, protecting. Find white spaces. As I mentioned before, finding white spaces is important because uh, big companies are investing in those gaps so as to conquer the whole domain. So you have to understand what are the gaps in the innovation where your solution can come in handy. Next stage after the research will be production. So production does not happen overnight. You have to select the best idea, you have to test, you have to build around the best idea, you have to do trial and run, you have to have enough data, and then you can evaluate the results to build a prototype. Now, where can you file for a patent? So you can plan for patenting even in the ideation stage. When you have substantial idea, when you have enough scientific data to support your innovation, it need not be in working condition, but the patent law requires you to provide working statement. You should have the ability to prove that it is working. But even at the theoretical stage, you can file for a provisional patent. You can plan and make a strategy accordingly. Now, what is an invention? As we discussed, invention is a successful technical solution. These are the three criteria which are required for patentability, which I'll be covering. So any invention should be novel, new, or not known to anyone. It should have inventive step, it should be non-obvious, and it should be capable of industrial application. We'll go through all these points shortly. First, we need to understand how to identify inventions. Now, as a company, you have to have the knowledge of potential sources of idea. You should know where to look. You should have a smart approach because that is better than the redundant work. Now, how can you identify inventions? These are the few of the sources listed for idea generation. You can have group discussions with your R&D team and come up with solutions. You can think of the existing product features and how you can make it better, because nowadays it's always version 1.0. These are the new solutions, and even if it is better, you can protect it through intellectual property. You have to listen to your customers, take their feedback, understand what they're looking for. You have to conduct market studies. Technology landscapes, again, you can go through patent and non-patent literature. You can read papers, what is going on in that particular domain. You can also look at your competitors, what they are doing, understanding which products or services they are bringing to the table, and you can study those to understand what is happening in the domain, so that you can come up with different solution or improved solution. Literature know-how is where you go through published patents and published research papers, or even product descriptions which are available online. So these are few ways to develop ideas which can, if they go through the journey of innovation to patent, can be patented in later stages. So understanding patent as a concept. Inventions, all inventions cannot be patented, but all the patents are inventions. Now, patent is basically a legal grant which is given by the government. It's a contract between you and the government where the government is granting you right to stop others. So it's a negative right wherein you can stop others from using, producing, reproducing, or selling your invention. It's your intangible intellectual property. So this is what a concept of patent is. What are the key features of patents? Protection of ideas that comprise innovative and qualifying features. It can be a product, it can be a process. There are, if I can suggest, go through Patents Act online and read section 3, which mentions non-patentable inventions, which clearly list out the things that are clearly not patentable in India. That will give you a generic idea of what can be patented. Protection is for 20 years from the first date of filing. It's protection from reverse engineering. It has high value of protection. As I mentioned before, patent right is a very broad right. It benefits of protection after the grant of a patent, but it starts with the date of filing. So between the time of the filing and the grant, if it takes, let's say, 3 years, it has, in my experience, it has taken as low as 6 months also to get a grant from the date of filing, but it has taken 5-6 years also to get a grant of the patent because prosecution takes some time at times. But the benefits of the patent starts from date of the filing. Now, patent is a territorial right, so you have to make strategies on filing Indian or international patent. As we were talking before, patents is a very vast area to cover. We'll conduct another session only for patents and processes and timelines later on. Now, I'll just brush through the patentability requirement or criteria. There are 3 important things for any invention to be patentable: novelty, non-obviousness, and industrial application. So novelty means it should not be disclosed anywhere. From the date of the filing, let's say you're filing patent today, so there should not be information published anywhere before the date of the filing. There should not be any document. We call it prior art. So there should not be any prior publication which is disclosing the features you're mentioning in your invention. That is novelty. Industrial application, inventive step is where there has to be certain technical advancement or there has to be economic significance or preferably both. So usually how they determine inventive step, which is determined while drafting also and while prosecution also, examiners also examine it. So it should be from a person having ordinary skill in the art. They should not come up with this solution just generally. On their daily workings, they should not come up with this solution. So there should be some thought, um, some input from the inventor, which makes it non-obvious. Economic significance, if you, I'll just give you an example. If there is a drug composition, if it is taking 100 rupees in today's date to manufacture it, and if your invention makes it in 50 rupees, that brings your economic significance, and that will give you inventive step over the present prior art. So that is the second criteria. Moving on to the last criteria, an invention must be useful or beneficial to the society. It should be capable of being produced or implemented in an industry. So any perpetual motion machine or ghost catchers are not having industrial applicability. So they will not be accepted as a patent. So in India, what we have as jugaad most of the times are not patentable inventions because they do not fulfill the criteria of patentability. That's it from my end. Sijo.
Uh, just a second, okay?
Yeah, we'll take the questions in the end.
Yes, thank you, Arshada. Thank you for a wonderful session. I think it was quite useful for the startups. So friends, I'll just quickly take you through a short presentation from the Innovation Society as well. We had recently launched two schemes, basically one to support patents and the other to support startups for their quality testing expenses. Basically a reimbursement which we'll be doing against the testing the startups are doing in their prototype development stage and things like that. So I'll quickly share my presentation. Just give me a second.
Hello. I just wanted to
Yeah,
check. Audible?
we can see.
Yeah. Yeah, I'm audible, right? Yeah, sure. Thanks. So guys, just quickly taking you, brief. I'll take a 2-minute slide on what the Innovation Society is, and then probably we can quickly move to the main portion of the presentation. So the Innovation Society is part of the Skill Development and Employment and Entrepreneurship Department, and we are the nodal agency for the startup ecosystem of the state. Having said that, basically we work for the startup ecosystem through different initiatives, largely guided by a policy which the state had launched in 2018, basically known as the startup policy. And the Innovation Society has a mandate into the for the execution of the policy. So we work in different fronts. Basically, our key objectives being, promoting and supporting the establishment of innovation-driven enterprises in Maharashtra. Largely, when we talk about this, it is more about, how do we create an ecosystem where, we can attract the right set of startups and startups benefit out of the ecosystem present in the state. And through that, the other objectives being, attracting angel funding and venture capital, and also largely creating job opportunities within the state. Uh, Through the policy, we are currently working on different mandates, right from creating physical infrastructure to supporting startups in different forms, right from helping supporting them in procurement, giving them access to the right set of network in terms of investor network or some understanding, giving them some mentoring network and things like that, and also giving them some direct benefits, which we will talk about in the slides going forward. Quickly taking forward some of the key initiatives which we have. Incubation is one of our major programs where we are supporting almost 17 incubation centers within the state, all spaced out across Maharashtra in tier 2, tier 3 cities as well. And we are supporting them to the tune of about 5 CR, and for a period of 5 years, for creating the local infrastructure for startups, and so that startups get the local assistance whatever they require. Incubation, we have another flagship event called as the Startup Week, wherein we reach out to startups to apply for innovative solutions, and this is done annually once. And what we do in the Startup Week is, like, we select 24 innovative startups and give them work orders worth 15 lakhs in different sectors, largely healthcare, agriculture, and sustainability, smart infra, governance, education, etc. uh, we have done this in the past, I mean, 3 years, I would say, consecutively, and successfully we have been running the edition and have come across very innovative solutions working with 72 startups. and we could give them, work orders close to 10.8 crores over these 3 years. The application happens normally in the month of April, but this year we did it in August due to COVID, and it was a complete virtual event where we invited applications from all around the country, and we got about 1,600 applications, out of which 24 were selected through multiple screening processes and things like that. Likewise, there are different initiatives. I'll just brief about a couple of them over here. One being the way I discussed about the physical incubation centers. We also have a plan in place to set up a virtual incubation center. Considering the present scenario, we think that this is more important in terms of giving facilities to startups, early stage startups, right from technology, marketing services, legal services, HR management solutions, and things like that, which can be given virtually as well. And that's how we are coming up with a Maharashtra Virtual Incubation Center. And the other initiatives include, supporting startups for IP and testing and certification support, which I will discuss in further. In the same way, we have a couple of other programs also lined up. We have dedicated women entrepreneurship cell, which will be focusing on women entrepreneurship, and there will be a program planned. There is, in fact, a program planned and should be launched soon about how to support startups. In fact, not startups. How to ensure that there is commercialization of research, and deep tech research being converted into startups is something which we are very keen on, and we might come up with a suitable program for that as well. Probably like something which supports researchers to leave their normal jobs and focus on the research what they're doing. So that's about the overall activities which the State Innovation Society does. We'll quickly, take you through to the new schemes which we have launched recently. One being the intellectual property rights scheme, which was launched a couple of weeks back by the Honorable CM. The core objective which we had for this program is, there has been in tier 2, tier 3 cities, largely, there has been very little adoption to the entire IP rights, what the idea about how to file a patent and what is a patent and things like that. And that's the very reason we want to, go ahead and, create that awareness and adoption. On having said that, the one of the most important parameters is also that startups face a lot of crash crunch in their initial days, and supporting them for these initiatives for filing a patent is something which we feel will add a lot of value in their entire journey, and that's where we come into picture. So we want to support them with cost, but as I mentioned, there has been very little access to startups in tier 2, tier 3 cities to the right set of partners, or I would say IP firms, which will support them to file patents. And that's where we as an institution feel that can play a major role in connecting them and assist and giving them the right set of assistance. So largely, when we started this program, these were a couple of 3 agendas which we want to cover, creating that awareness, supporting them with some cost to it, and giving them the required assistance for the entire program for filing their patent. And when we talk about this program, this is largely a program supporting patents, industry design patent, the way Harshada explained it, trademarks, and copyright. In copyright, we are restricting ourselves to supporting them for the computer code as of now. Quickly moving to what is the program all about, who are eligible, and probably the services what we're trying to offer. This being a state-run program, this will be for startups incorporated in Maharashtra. They have to be a DPIIT recognized startup. That is the recognition given by the central government for startups based out of India. So they have to be DPIIT recognized and incorporated in Maharashtra, and also register on the MSNS website. So when we say about the scheme, we are very focused on supporting early stage startups, and that's the reason as of now, the revenue for domestic applications has to be less than 1 crore cumulative from the date of inception. And for international applications, the revenue has to be less than 5 crores. This is the basic eligibility criteria. Further, we'll be also discussing some other parameters also, but this is something which is critical in understanding who are eligible for the scheme. What we have offered is something which we feel is the need of the hour for the startup ecosystem. There are two things to it. One is when you're filing a new filing for a new patent, MSINS has identified leading empanel partners, and they will work with you in filing the patent. Or if you have already filed, or you don't want to use the existing empanel partners, we will be supporting you through the reimbursement process as well. So there are two approaches to the entire IP scheme. One is if you don't have the right set of partners, you can file your patent through the MSINS portal and associated empanel partners. Or if you have or if you plan to do it from some external from some other agency, you can reimburse it as well. So I think some people had query from when it is being applicable. The IPR application should be filed or granted after the scheme has been launched. So basically, the scheme as in the GR for this was launched in 18 September. And due to Corona and all of the other factors, there had been some delay in the launch. But yeah, we could do it as soon as in the month of Jan itself. But yeah, it is. But we have insisted the government, because it was launched in 2019. We need to give support to those startups as well. So that is an effort which we have taken, and I think you can apply. Anyone who's filed it or got grant after 18th of September can apply for this. So what exactly is the support which we as the Innovation Society is trying to give? For domestic filing, we are giving a support of up to maximum 2 lakhs per startup. And for international filing, we are giving each startup a support of maximum 10 lakhs. So the way it goes is the support model which we're talking about. If you're a startup who has raised less than 3 crores of funding, I mean 0 to 3 crore, MSINS bears 80% of the contribution, and the startup bears 20% of the contribution. And if you are a startup who has raised above 3 crores, then MSINS MSINS and startup both will be contribution from both sides will be about 50% each. So basically, if you look at it, it has to be for early stage startups with revenues less than 1 crore for domestic application and less than 5 crores for international application. And the funds raised should be, if it's less than 3 crore, the state will support them with 80% of the total amount. And if it is above 3 crores, the state will support with a 50% contribution. So that's how the entire model is. I will also quickly take you through the process. When we say that it's a 80% contribution and a 20% from the startup, it is largely defined in the guidelines which is being published by the government, the scheme which has been published. So if it is a patent, if you're applying through our empaneled agencies, what happens is the 80% of the cost will be given to by us to the empanel agency, and the remaining 20% has to be given by the startup to the empanel agency. And the rate for that is being clearly defined in the GR. So basically, the rates is a quite exhaustive sheet. That's the reason we haven't put that, but it's available on our website as well. The rates will be as per the rate card which is mentioned in the GR. So for any of the schemes, even if you're applying from outside as a reimbursement, you will be getting the rates, either the rate card or the one which the patent officer, which you have, or the invoices which you're raised for, whichever is lower. So how the process is basically, it's fairly a simple process. As we defined, there are two approaches to it. One is you want to file it through MSINS. It's very simple. You file it. The application is filled on the MSINS website. You register and fill the details, required details. There is a preliminary screening which is being done at our end through a process partner. We had shortlisted a process partner, and Lexorbis is the process partner for this program, who will be doing an initial screening of all the applications. Basically, there will be an initial knockout search which will be done, and each application will be screened there. The reason we have kept this step is to ensure that there aren't any entries which are not relevant to patents or something which is not very keen, which is not patentable or things like that. So that the amount which is being amount is utilized to the right set of beneficiaries. And what is happening is, at this stage, at the first stage where the preliminary screening is to be done, the startup has to bear an amount of 4,720 rupees, which the applicant has to apply for the preliminary screening. And if the application is selected further, I mean, the application accepted, it will be reimbursed in the 80/20 model, which I just explained. And if it's not selected for the next filing, then the refund won't be done. So this is just to ensure that the right set of entries come and the further funding is being utilized well, and also to ensure that that the startup doesn't bear any problems further once the application is shortlisted or for filing. The 4,720 will also be reimbursed. This is the process for filing a new application. Just a two-step approach. One, wherein you'll be filling all the data, and the preliminary screening will be done by a screening partner. And coming to the next step, where once the screening partner is accepted, the startup gets an option to select from 4 to 5 leading empaneled agencies, and they can further work with them on filing the patent. So that's how the new filing process is. If you look at the post grant, it's fairly simple. You need to fill in your application, and you have to fill in the application, and once the screening partner processes it, the reimbursement process will start. So for post grant, if it's a domestic patent, there won't be any charges applied for it. Only if it's an international post grant, there will be a minimum of again 4,720, which again will be as per the reimbursement process, which the reimbursement will happen. So basically, the international patent is for post grant is also charging 4,720, because there are multiple agencies to which we have to reach out to and understand what is the basic whether the patent is actually granted for international patent. So yeah, that's how it is for IPR. And let me just quickly go through the other scheme also, which Honorable CM had launched. Basically, the quality testing and certification scheme, which was launched, was also keeping in mind, that the Innovation Society had done a background research in understanding what are the pain points of startups, and in different sectors, what was identified that startups do have a lot of problem in not in testing. Basically, I would say once the prototype is made, the testing it at certified labs is an expensive cost which they have been incurring, and that's the reason we have come up with this program, where the key objective is to make sure that the startups incorporated in Maharashtra focus on product development, and associated costs in testing will be supported by the state. And also this ensures that their products are proven, and they get a much better global exposure to their products with the certifications which they do. So the only support which we'll be giving is in basically reimbursement, and the reimbursement will be done to the tests which are being done in NABL recognized or BIS recognized labs. So just quickly moving, this also requires a minimum of eligibility criteria. It has to be Maharashtra-based DPIT recognized startup. Have to register on MSINS, which is fairly an easy job. In this case, we want to ensure that there are more people though they will be early stage, but there are more people taking the benefit of this, and that's why we want to keep the turnover. I mean, the annual revenue should not have crossed 1 crore. So it's annual revenue which shouldn't be crossed over 1 crore, and funds raised should not be more than 3 crore. So that's the eligibility criteria. And coming to the financial support which we are giving up to 2 lakhs of support per startup, which will be again the 80-20 model, where MSNS will reimburse 80% of product testing and certification cost incurred by startups. This is also fairly an easy process. You just need to register. There will be an eligibility check which will be done. You'll have to, submit the required documents for the eligibility check, and the applications will be evaluated at the MSNS end, and the reimbursement process will begin accordingly. So fairly, this is the quality testing scheme which has been recently launched with the IP scheme, and I think all the startups should take maximum utilization of this and ensure that the startups have been ensure that they before the funds getting basically the yeah, there was another question about till when does this last? It's a newly launched scheme, and the government is very clear that it is for the support of the startup ecosystem, and it will be there for some time. But the point is, as startups, we would love you guys to apply for it and ensure, so that we also get some benchmarks and data points where we can show it to the government that, okay, this is quite important, and then it will be a continual process year on year to start with this. So that's it from our side. I hope I have covered all questions. If I haven't, I will just try to answer. Neil, any questions? So I think there is some query on whether it's for post grant or new patent filing. It's hello. Yeah. Hello, Dave.
Yeah.
Yeah. Just answering the previous question, sorry, there was some internet fluctuation at my end. Any startup who wants to file a new patent can also apply, and anyone who's granted a patent after 18 September 2019 can also apply through the reimbursement route.
Okay. And there's a question from Devdutt in the chat, Sridhar.
Okay. Yeah, so for certification grant, if the product fails in achieving the certification first attempt, then still the incurred cost eligible for reimbursement. Yes, Dave, you will be eligible for the incurred cost for testing. Basically, till the 2 lakh limit, you can utilize that. Yeah.
And Vijay wants to ask a question. Vijay, please go ahead.
Hey, hi. Can you guys hear me?
Yes, Vijay, please go ahead.
Yeah. So just one quick question. I hope the PCT application is, kind of eligible for the international filing in patents.
Yes, Vijay. That's up.
Yes, it is. It is.
Okay. And one follow-on question was, for the quality testing, I understand it's, kind of restricted to NABL and BIS certified labs only in India. But are you guys looking at kind of incorporating more international bodies under the purview of the the scheme going forward?
Yes, Vijay, if you can just write to us specifically which bodies you are looking at, we can definitely have a look at it.
Okay, cool. And one last just concluding thing would be that once you've kind of screened the application, how do we need to kind of submit the account details and stuff? Is it over email or through the portal?
For the reimbursement, it will be through the portal.
Yeah. Okay, great. Thank you, guys.
Yeah, Vijay. Thanks.
Alden, you have a question. Please go ahead.
Yeah, I don't know whether this was discussed. We want to check about a utility patent. So, is there some dope on that we have, and how long does it take to file one? Thank you.
How long? Harshada, can you just help us with this?
I couldn't hear the whole question. Can you please repeat once, please?
Yeah. Firstly, what is a utility patent exactly, and how does one benefit from applying a utility patent? And what is the cost for it, and how long does it take to attain the utility patent?
Okay. So
Thanks.
firstly, utility patent is the same as patent. There are two types. In India, we do not call it as utility patent. Earlier, it used to be called as utility patent, but utility patent is basically patent. So how long does it apply? Does it take? So it depends on what information you have. If you're ready with all the scientific data which needs to be submitted and all the forms are prepared with your inputs, then it can be filed as soon as possible. Through the scheme, you have to go through the portal, fill out the form. We'll go through that in a week's time. We'll screen your application and get back to you, and we can begin the next procedure thereafter. So time, we cannot really say, there is no set time. If you're ready, if all the information is present, that it can be processed quickly.
Okay, so it's just like any other patent, and it's just that it's called utility patent. Rather, it was called utility patent earlier, but it is the same like a normal patent, basically.
Yes.
All right. Thank you so much.
No problem.
Devdutt, you have another question?
Yeah, thank you. See, I was asking that there are some organizations in the international platform who has patented some of the processes, business processes, like how to service or how to market a product. Like Herbalife company, who is in health products, they have made a marketing model and they have patented it. Now there are companies who are patenting the service model also. So whether such more possibilities are there in our case also, that we can patent some processes like this?
Okay, the Section 3 of IP Patents Act of India does not allow patenting of business processes per se. But if we can draft it in a way that it is some service or there is some solution approach to an existing problem, we can definitely go about it. Secondly, in US, processes can be patented. As I mentioned before, patent is a territorial right. So for every country, different law exists. There are some common baseline foundation for patenting, which is novelty, inventive step, and industrial application, which is applicable throughout the world. But for non-patentable subject matter in India, strictly business processes are not allowed. Although if, as I said, if there is some solution or some process that we can put it in a way, then we can go for patenting it. But if it is only business process, it cannot be patented.
Okay, when you are talking of the territorial processes, I mean territorial subjects, then there are some certain things probably are applicable in US, and those things may not be patented in India. So in such a case, are we eligible to file the patent in India for the same or similar subject?
Yes, you are. You have to get permission from the controller for it. So Controller General of Patents, we have to apply for a permission. So there is a separate process for getting that permission.
And our IPR consultants, what are available from MSINs, they will help us in doing the research and raise the questions regarding, which can be answered by the applicant, so that the patent can be the entire subject can be driven towards the actual fileable patent.
Yeah, we can do that. So you can contact the empaneled facilitators which are listed on the website, and you can have a conversation regarding that.
Okay, thank you very much.
Thank you.
One question for the certification person. I forgot his name. There are possibilities that some labs can be established for testing in-house laboratories. So whether MSINS or the government of Maharashtra has some facility for to raising such setups in-house in the company, but that is to actually meeting the standards of international standards.
So Dave, currently the scheme is for just testing, setting up of labs. This won't be covering that portion basically. But other than that, I'll have to check whether there are any schemes wherein if you're setting up labs, if there is any financial support being given by the state entities. I need to check on that. I'm not aware of one.
Because what happens that if you want to take it to the certification for other external lab, before that you have to do a lot of testing in-house. Then only you can take it back to them. So a lot of expenses goes in the in-house testing before you actually go out.
Okay, but in the in-house testing, how is that infrastructure very costly, or there are some grants which probably even I was talking about the research grants which we are going to bring about, or there are some central entities like DST and BIRAC which give grants to research. Are these labs somewhere which are these grants supporting? Would support such labs, or it's much expensive than what is being supported by DST and BIRAC?
Not very expensive as long as the big organizations. For startup, it is really expensive. Actually,
for example, there are grants, about 10 lakh grant which is being given by DST or BIRAC for research. There are some programs also. Probably applying for that might make sense for incurring for these costs which are incurring in-house costs which are incurring.
What is DST?
Departments of Science and Technology.
Okay.
Yeah.
Thank you.
Yeah, and we are also coming up with such programs where you can apply for that.
Okay, that's nice.
Yeah. Yeah, so there was a question. Shraddha, is there any deadline? Shraddha, there is no deadline as such. It's all first come, first serve basis till actually the fund launch. But yeah, it will be for a longer period. It doesn't have a specific deadline as of now.
Yeah. So this is Vineet here.
Yeah,
I have a question, like how to define the approach in terms of filing the patent, whether we should go for international or Indian. Like, what could be the factor that will define that we should file this internationally or we should file it for India, or whether we should initially go with Indian market, Indian patent filing, and then to go for international. Like, what could be the decision-making factor while taking this particular step?
Okay, I'll answer that. So first thing is you have to understand what is the geography you're catering to. If you're planning to expand your business in US, then definitely go for filing in US. If you're not planning to have operations in UK, then don't file in UK. It's as simple as that. Secondly, timelines. You have 1 year of time after first filing to decide if you want to go for international filing. So you can use that time in developing that strategy, that where you're going, where your future customers are going to be, where your market is going to be, or if you want to license it in that geography. So because patents are territorial rights, you have to make that decision in the set timeline of 1 year.
So followed question, like if we decide to initially go with India, and then eventually within 1 year we have to decide whether we want to go for other territories or not, if I'm
Yes.
not wrong. Right?
If you want
Uh,
to use the same filing date, yes, because there is something called as priority date. So you can actually make use of your first Indian application and use the same
Mm-hmm.
date, same files for filing through other countries. So in our
Okay.
later on sessions where we are going deep into patents, I'll explain about the patents and timelines and what are the treaties, international treaties.
Okay.
Okay.
Okay. So just to say, we operate not in Europe or US market, but we are expanding in Middle East market.
Mm-hmm.
So whether territorial patent filing covers these areas as well, country specific?
You have to file in those individual countries.
Okay. Okay.
Yeah.
So any filing for international can be done for those respective countries, and the scheme what MSINS is stating about can be applicable for those regions as well, not specific to US or Europe, but for
Yes.
any international.
Yes.
Okay. Thank you.
Yeah. Can I just
Yes.
Sure.
just a follow-up question on Vineet's query. So let's say we have a startup, or as an entity, we show that we want to roll out the product at the same time world over, or at least in the major markets, international markets, together with India. Then in that case, is there any methodology which allows you to kind of have a patent filed which is valid to all those markets that you want to operate on? Let's say the US market, European market, and Asia Pacific markets together. So can I apply for a patent which kind of enables me to kind of have the patent entitlement in these countries as well at one go itself?
Yes, so one of the ways to go about it is PCT application, but PCT is merely a gateway to enter countries which are parties to the Patent Cooperation Treaty, that is PCT. So through PCT, you'll get the same priority date and you'll get 31 months to file in individual countries. So individual countries, you have to file the application because laws are different for each country. There is
Okay.
a process is different, timeline is different, even the fees are different. So individual country application is mandatory. There are two ways to go about it. Either you can go for direct filing, directly you can go to the country's IP site and apply, and secondly through PCT, which is one application, and national filing later on you can do.
So ultimately, you have to file an individual patent in the respective countries.
Yes, but for
Yeah.
PCT, you get more time because you can
Okay.
file PCT within 1 year. Like I said, within 1 year, you have to decide either if you want to go for direct filing, you have to decide countries at the very first go. That
Okay.
within 1 year, you have to file those. Through PCT, you get total of 31 months. So you get
Okay. Fine.
additional months for deciding which countries you want to go to.
Okay, fair enough.
Yeah.
So while let's say, for example, in the 31 months which is there, there is a patent dispute, there is an infringement. So then what happens in that case? Yeah, hello. Did you get my question, Harshada?
Harshada?
Shraddha, you are on mute. Can you unmute?
Hello, is Harshada there?
We can hear you, Aldrin. Harshita is apparently on mute.
Oh, okay. Okay, maybe somebody else can ask a question. I think fine, we'll get back.
Yeah. I don't know if you can just mail it to us. We can discuss that with Harshada.
Okay, fair enough. I'll do that. Thank you so much.
Yeah, yeah.
Someone has
Deepak, you
asked
have
about
another.
IP valuation. I'll just briefly tell you how IP valuation works. So like any other audit, there is audit that is conducted. IP valuation is a complicated process based on the validity of your patents, which countries it is valid in, and what is the domain depth, what are other inventions doing in the domain, and how much money it is making. Based on that, IP valuation is conducted. So IP valuation is usually conducted on patents, but it can also be conducted on the whole IP portfolio. What is the brand value? So I'll give you a simple example like Apple. Apple trademark will be valued much more than let's say some other phone, Micromax, which came up much later and has a smaller market capture. So that's how IP valuation works.
Yes. Devdutt, you had some query or it was raised before?
Yeah. No. Actually, I had a question about when you talk of the territorial IP, whether EU is considered as one, or you have to go for individual countries in EU, in Europe.
So there is European Patent Office. They have one patent office, but when you go for national phase filing, you have to file in individual countries. You have to submit translations in their local language. So you can check out eSpecNet. That is, I'll just type it out. It's a European Patent Office website. I'll just send you the link. You can check it out.
Thank you.
Vaibhav has asked a question. If we have got patent in India, can we get help of MSIN scheme to apply for industry patent? Yes. You can apply on the portal, Vaibhav. You can get access to it. You can definitely apply.
Just check for the timelines. It needs to be within the valid timeline. So if 1 year has not passed, you can apply for a patent, international patent.
Yes. Are there any more questions? Vijay, you had a follow-on question?
Hey, yeah, something just came up to my mind. So for the quality testing reimbursement, there is no screening fees, right? Because I cannot see that on the portal.
No. It's
Okay.
correct.
And the same date eligibility of 18th September something also applies for quality testing. Like it has to be done post that.
Yes.
Okay. And the third would be, is there any upper ceiling or an upper kind of a date till which a startup can come back to MSINS, for kind of reimbursement? Like, is it 2022, 23, 24, something like that? Or is it like open-ended?
It's open-ended as of now, Vijay. I mean, we might get basis the program success. It will be evaluated after say 6 months or a year. Then accordingly, the budgets will be allocated for that. If it's quite, we need to ensure that it's quite helpful for startups, and accordingly there will be budget allocations for this.
Yeah, understood.
Yeah.
Okay, thanks.
Vijay, the reimbursements for testing, as of now, it is open from the date of the GR it was launched for this financial year, that is 31st till 31st March 2021. After that, the bills bills only with 3 months validity will be accepted. I mean, not before that, not prior to that.
Okay. So I've done a testing in 2020 March. So
yeah, that's
at least for now it's okay, right? You're saying?
Yes, definitely.
Yeah. I think that's a good consideration, because given COVID was given in the mix, last year. So I mean, schedules were which was haywire. So I think it's good on your part to do that.
Yes, definitely. Thanks.
Yeah. Okay, guys. Thank you.
Thank you. Thank you. I think we can close this. I think there was a question, how many startups are benefited? The scheme is just launched 2 weeks back, Dhananjay. So we are yet to get some good results on it, but I think 5 to 10 startups might have benefited as of now. I think we have got over 50 applications which are under process now. Okay, then probably we can conclude if there are no more queries. Okay. Thank you, Shila. Thank you for making it, and it was a detailed presentation. In fact, Dev, you were saying something?
Yeah, so I was saying to all the participants, do look out on our social media. We'll be organizing a deeper session on patents itself, as Harshita mentioned, because it will require a lot of more time, like the timelines, etc., country-specific patents. So do check out our social media. We'll definitely post a new session very soon. And thank you for attending. Thank you, Harshita, for a very interesting session. I also learned a lot from this session. Any closing thoughts, Harshita?
Yeah, thank you so much. I'll just write my email ID. If you have any questions, you can just send it to me and I can see how I can attend it to it.
Great.
Yes.
Okay,
And
thank
any
you.
of the startups who haven't registered on MSNs, we request you to please register because we send out news, fortnightly newsletters where also you'll get updates about the ecosystem as well.
All right. Thank you, everyone. Thank you for always supporting us. We look forward to interacting with you again. Thank you, everyone. Thanks a lot.
Thanks. Thank you.
Thank you, guys. Thanks for a great session.
Thanks.
Yeah,
Bye.
hi, Manjari this side. If it is not too late to ask a question,
Sure.
um, I would like to. Yeah, first of all, thank you for a great informative session. Definitely, it clarified a lot of things and also helped in understanding what are the different schemes and overall about patents and trademarks. So the question is there an entity or anybody in this process or any other entities who can help in identifying what is a patentable or what is what where we can create a copyright or trademark or IP in a startup. I mean, identification of that is something where some of us might need help. Either in this process or any particular kind of people or entities who are I mean trained to do that. Can you suggest anybody? Yeah.
I'll take this one. So any IP lawyer can help you out with this. You can contact the empaneled facilitators which are there on the portal. You can write to me. You can contact anyone in the field of intellectual property. They'll be able to help you in identification of IP.
All right. All right. Thank
Okay.
you.
Thank you.
Great. Thank you, everyone. Thank you.